Okay, I think we should get started. We still have a few more people joining us, but we have a lot to cover, so we're going to get started now. Welcome, everybody. My name is Peter Frumhoff. I'm the Director of Science and Policy at the Union of Concerned Scientists. And on behalf of UCS and our partners, the Sabin Center for Climate Change Law at Columbia University, the Earth Institute at Columbia University, and the Climate Science Legal Defense Fund, I'm really delighted to have you join us for today's webinar on science, climate litigation, and the law. Over the past several years, there's been a dramatic increase in the number of lawsuits seeking to hold both governments and companies accountable for their failure to take aggressive climate action. Clear and compelling scientific evidence of the causes of climate change, of the current harms we're experiencing across the world, and of further risks if we don't take strong action form the basis for our understanding of the urgent need to act now. Scientific evidence is also playing a central role in many of these lawsuits. Yet today, very few scientists think of themselves as doing climate litigation relevant research. Many in the climate science community are comfortable doing and think of themselves as doing policy relevant research, but less so with respect to litigation. And few have more broadly access to opportunities to draw upon their expertise to inform current and emerging climate litigation and the law. At the same time, many in the legal community who are involved in litigation often don't know how best to engage scientists across disciplines relevant to their lawsuits, how to draw upon their expertise. This 90-minute webinar today is intended as a platform on which to begin to build out and strengthen connections between science and scientists and climate litigation. I'm pleased to say that the interest in this topic is large, as evidenced by the more than 650 registrants for today's webinar from more than 30 countries, from nearly all US states, including also the District of Columbia and Puerto Rico, and a very broad range of relevant disciplinary backgrounds. If I can have the next slide, please. Today, I'm very pleased to bring to you a very distinguished panel of legal and scientific experts to speak to this nexus from diverse and complementary perspectives. You all should have their bios, so I won't plan on introducing them in any depth. We've asked each of our speakers to make short presentations on the order of 10 minutes to frame up the key issues. During their talks, we invite all of you to put questions in the Q&A function on Zoom, and we'll hold considerable time to take on these questions after the presenters have made their initial talks. And in my closing remarks, I'll also provide some further opportunities for those of you who are interested to engage beyond this kind of front-end platform that we're building today. So with that, let me turn now to our first speaker, Michael Berger.
Good morning. Sorry for the slight delay there. Thank you, Peter. And let me also say thank you to the Union of Concerned Scientists, my colleagues at the Earth Institute and the Climate Science Legal Defense Fund for working together to convene this and co-sponsor this event. I'll dive right into it. We are not on track, as everybody on this call knows, to limit global warming to 2 degrees Celsius or to 1.5 degrees. The emissions gap between where we are and where we need to be can also be thought of as a policy gap. Governments are not acting quickly enough to control and reduce greenhouse gas emissions or to adapt to climate change, and neither are actors in the private sector. In the United States, this policy gap is growing due to the Trump administration's deregulatory policies and policies aimed at growing fossil fuel production and use. In other countries, situations vary, but in many of them, there are similar increases in emissions taking place. Many view judicial intervention as a necessary means to address the inadequate policies and regulations, as well as corporate action. At the Sabin Center, we track climate change litigation, both in the United States and outside of the United States, and make our databases freely available on our website through these climate change litigation databases. Most of the litigation worldwide takes place in the United States. It is approximately 10 times the amount of litigation we see in the next largest jurisdiction, which is Australia, or the UK and the European combined. But there is an increasing, as Peter mentioned, there is an increasing number of cases we are seeing in many jurisdictions around the world. And one of the things that we are seeing is that litigation, while formerly largely concentrated in the United States, Australia, and the EU, is increasingly geographically diverse. And we are seeing an increasing number of cases in jurisdictions where previously there was none, including an increasing number of jurisdictions in the global South. We are also seeing, in addition to the increasing geographic diversity, just a sheer increase in the number of cases that are being brought in aggregate and year over year. This chart shows the increase up until 2017, but the numbers since then have been consistent. Now, there are four main types of lawsuits, and climate science, including attribution science, plays a key role in each of these. There are lawsuits versus governments for failure to address greenhouse gas emissions. In these cases, plaintiffs generally are seeking policies and regulations to reduce greenhouse gas emissions or curtail fossil fuel production and use. And Tessa Khan will be speaking more about this later on in our presentations. There are lawsuits versus private actors seeking to impose liability or to force action for their contributions to climate change. In both of these instances, attribution science helps to inform the discussions of both harm and responsibility. Another type of lawsuit are industry lawsuits challenging government policies aimed at controlling greenhouse gas emissions. So climate change litigation is not unilateral. It does not move in one direction. The courts are also used by the regulated entities and by political representatives for national governments and subnational governments that want to either defend policies or challenge policies. Defend policies that are deregulatory or challenge policies that they believe go too far. In this case, attribution science plays a role in defending or attacking those policies. There are also lawsuits involving climate change impacts, adaptation, and risk disclosures. And here, attribution plays a role in seeking to show that there's a real risk or impact that needs to be considered, either in relationship to endangered species or habitats, in the context of environmental impact assessment, or in other statutory and regulatory contexts. In a recent paper, Jessica Wentz, who will be talking a little bit later, our colleague Bradley Horton at Vermont Doherty Earth Observatory, and I look at the relationship between attribution science and the law. And this is the Law and Science of Climate Change Attribution paper. There are several key aspects of DNA science that we identify in the paper. How are human activities affecting the global climate system, climate change attribution? How are the changes in the global system affecting other interconnected natural and human systems? Extreme event attribution, that takes a look at how changes to the global system are affecting the frequency, magnitude, and other characteristics of extreme weather events. And then source attribution, or what we call source attribution, which takes a look at the extent to which different sectors, activities, and entities have contributed to anthropogenic climate change. In the litigation context, attribution science is central to resolution of a number of key legal questions, including standing, causation, and apportionment of liability. Arguably, it is a little bit less central to resolution of justiciability. The question there is more about separation of powers and whether courts are really the proper place to resolve the questions at issue. However, attribution science plays a limited role even in this context. For instance, courts may note that due to the diffuse nature of climate change, complex causal chains, so forth and so on, that other branches of government are responsible for addressing climate change. Now, as I mentioned, Tessa will address climate change litigation against national governments. For the few minutes that I have left, I'd like to introduce some of the climate cases that we are seeing against private actors seeking to impose liability for climate change impacts. What you see here is a chart representing the cases that many of you may have heard of brought by state and sub-state and local governments against the so-called carbon majors. Full disclosure, I do work with Scher Edling, a law firm that is representing a number of the plaintiffs in these cases, though my presentation of these cases has nothing to do with my role with the firm or as counsel to some of the plaintiffs here. All I mean to note here is that these lawsuits raise issues related to several different types of impacts: sea level rise, changes to the hydrologic cycle, impacts on public health, among other things. They operate under, they raise a number of different legal theories, including public and private nuisance, product liability theories, and failure to warn, as well as an increasing number of claims brought under state consumer protection statutes. The cases here are at all different stages of litigation, and I don't have time to summarize that, but I would be happy to talk about these cases in particular during Q&A if there's interest in it. The litigation against the fossil fuel industry is not limited to the United States. There are also lawsuits and investigations that are being undertaken outside the United States. This includes the investigation brought by the Philippines Human Rights Commission into the so-called carbon majors in the case of INRE Greenpeace Southeast Asia, a lawsuit brought by a Peruvian farmer against the German utility RWE, seeking compensation for impacts, local impacts to a glacier that threatens his farm, and lawsuits brought by different nonprofit, non-governmental organizations in France and the Netherlands, seeking to force large energy companies there, Total in France and Shell in the Netherlands, to reset their course in a manner consistent with a 1.5 degree pathway. Now, there's another category of cases seeking to impose liability, force action, or recover damages for governments or corporations' failure to adapt. These cases rely both on establishing the foreseeability of different kinds of climate impacts, as well as the causal connection between climate change and the impacts that are projected or experienced. There are several avenues that are available under domestic law. These are in the United States, but in other jurisdictions, there are domestic avenues available as well to try and force or mainstream climate change impact assessment in a number of different ways. But we have also seen cases seeking monetary damages and to impose liability for the failure to adapt in response to extreme events. Occurrences. So during Hurricane Harvey, the Arkema chemical plant flooded and lost power. When refrigeration went down, there was a volatile chemicals explosion, releasing a toxic cloud. And we have seen a number of different kinds of lawsuits brought there, including criminal, statutory, and negligence claims. The negligence claims have been consolidated in a multi-district litigation and are underway. Similarly, the series of wildfires that, a previous series of wildfires culminating in the Camp Fire of 2018 brought about litigation both in the corporate context, where bondholders were seeking damages, as well as in negligence contexts where people impacted by these wildfires filed lawsuit against PG&E, ultimately leading to the utility declaring bankruptcy, from which it has now emerged. So there's much more to talk about climate litigation and the relationship between climate science and these lawsuits. And we'll hear a lot more from our other speakers. So I look forward to the Q&A part of this, as well as hearing from others on the panel. Thanks, Peter.
Thank you very much, Mike. So next up is Tessa from the Climate Litigation Network.
Thanks so much, Peter. I really appreciate the opportunity to participate in such an interesting discussion with all of you. As Mike mentioned, I'll be providing an overview of trends in climate litigation against national governments outside of the US. And I'll say a few words about the kind of scientific input that's needed to strengthen these cases. And as Mike said, there's been a particular surge of interest in bringing cases against governments that try specifically to compel more ambitious mitigation action. And those are certainly the kinds of cases that I and my colleagues work on and are supporting in several different countries. So this might be obvious to all of you already, but I think it's worth spending a couple of minutes just on why cases targeting national governments for their inaction on climate change is such an attractive strategy at the moment. The first reason is that governments are, of course, the only institutions that are positioned to enact and invest in the kind of sweeping structural reform that we need if we're going to reduce emissions at the speed and scale necessary to stay below 1.5 degrees of warming. And over the course of 26 years of international climate negotiations, governments have also repeatedly accepted in decisions and agreements adopted at the end of annual UN climate talks that they're responsible for the emissions emanating from their national territory. They've accepted the risks associated with climate change. They've accepted how far we are from the goal of stabilising the concentration of greenhouse gases in the atmosphere. And they've accepted that rich countries should take the lead in reducing emissions globally. The legal duties that governments have to protect us, us being communities, residents, and citizens within the jurisdiction of states from foreseeable harm, those legal duties are also well established and long-standing in many countries, whether they're anchored in human rights or constitutional or other legal frameworks. So that's not to diminish the significant challenges associated with bringing these cases and the novelty of the issues and arguments that we have to present to courts. But I think there's an intuitive understanding among many of us that governments bear ultimate responsibility for protecting us from the climate crisis, and that there needs to be accountability for their various failures over decades, including, of course, their active support for the fossil fuel industry. So with that understanding, it's easy to see why there's been this steady rollout of cases against national governments across the world. Cases that seek to increase the overall ambition of emissions reductions have been filed in North and South America, in Europe, in Asia, and in Africa. There have been key wins in the Supreme Courts of the Netherlands, Ireland, and Colombia. In the Netherlands, my organisation, Agenda, which houses the Climate Litigation Network, successfully sued the Dutch government, which resulted in a court order that required the government to reduce national emissions by at least 25% by the end of 2020, which led to the government this year shutting down at least one coal-fired power plant, phasing out the capacity of the remaining coal-fired power plants in the country by at least 75%, and investing €3 billion in a range of other decarbonisation measures, which I think is indicative of the kind of impact that these cases can have. We also recently supported a case against the Irish government, which led to the Irish Supreme Court in July this year annulling the government's main mitigation strategy and requiring it to devise a new mitigation plan that clearly puts the country on track to meet its long-term emissions reduction targets. And finally, in Colombia, there was a landmark victory against the government in 2018, in which the Supreme Court found that the government's failure to curb the deforestation of the Colombian Amazon was a breach of its human rights obligations. And the Supreme Court recognized that the Amazon itself is a subject of rights. I think that one of the lawyers involved in that litigation, Cesar Rodriguez Garavito, may be on this call. I hope he is, and I'll happily defer to him for any further explanation of that case. There are also a number of important cases that target governments for their support for a particular carbon-intensive project or policy, including, I think, an especially important case that will be heard in the Supreme Court of Norway in November this year, in which plaintiffs argue that the government's decision to issue a new round of licenses for oil and gas production in the Barents Sea is unlawful. And there was also a recent successful challenge against the UK government earlier this year, in which the plaintiffs were able to successfully challenge the expansion of Heathrow Airport. As Mike's outlined, cases against governments also include so-called adaptation cases, where individuals or local governments challenge state failure to adequately prepare for the impacts of climate change. And that includes a successful case that was brought by a Pakistani farmer against his government, arguing that its failure to implement legislation that's designed to protect communities from the impacts of climate change was a human rights violation. Obviously, the type of scientific evidence that's required to support these cases varies widely depending on the kinds of arguments that are being made. And from what I understand of the remarks that my fellow panelists will be making, I'd broadly endorse all of their recommendations and suggestions to the scientists listening. But I can make a few general observations about the science that's being used to support these cases asking for more ambitious emissions reductions policy at the national level, and some of the gaps that need to be filled. Although I'll specifically refrain from discussing the Juliana litigation because I know that Jessica's got that covered. The first observation is that a number of these cases, including the Dutch and Irish cases, rely heavily on the findings and conclusions of IPCC reports. One of the main reasons for this is the difficulty that governments have challenging those conclusions, given the IPCC is an intergovernmental body, and governments approve and adopt line by line the summary for policymakers that forms a part of those reports. Indeed, our experience is that governments don't contest IPCC findings in court. There are, of course, some very good reasons that you shouldn't rely on those conclusions. They're often very conservative, but for establishing some of the basic findings of climate science and the overall trends and impacts, I think the reports are an invaluable resource. And in fact, neither the Dutch nor Irish plaintiffs relied on scientific evidence beyond reports published by the IPCC, the UN's Environment Programme, and publications by their respective national scientific agencies and authorities. That said, most cases will require evidence of current and projected localised impacts of climate change, which will often need to be supported by new research. One of the other key scientific questions, which is actually really both a scientific and a normative question, that courts grapple with in these cases is how much each country ought to be doing in terms of emissions reductions to contribute to an overall temperature goal or concentration level, whether that's 1.5 degrees or 350 ppm or some other standard. Inevitably, and I think this has been borne out by recent cases, courts look for some objective benchmark or standard against which they can evaluate the actions of governments and determine whether or not, even if they afford governments broad discretion, governments are still acting in a way that falls below a minimum level of action that they're required to take to satisfy their legal obligations. And that, of course, requires courts to engage with the very vexed question of, what's called effort sharing or burden sharing between countries, which is, of course, a very contentious aspect of international climate negotiations. And to that extent is, as I said, a normative question as much as it is a scientific one. But I think that said, we certainly think that it would be incredibly valuable to have more scientific papers that model effort sharing, that provides courts with updated guidance as to how much individual countries need to reduce their emissions in order to contribute towards agreed temperature goals. There are, of course, some approaches to effort sharing that work clearly to the advantage of those countries that are already the most polluting, but we think that there are principled legal bases on which to exclude those sorts of approaches so that courts are presented with a more managed quantitative range for each country. We've given a bit of thought to this question, and my colleague Dennis van Berkel recently published a piece in Nature on this topic, which I think we're going to share in the chat box for those of you who are interested. The final thing that I'd say, mindful of the time that I have, is that it would also be very valuable to have more analysis of the costs and risks associated with individual countries delaying emissions reductions in the short term. What we find is that governments in these cases routinely argue that delays in short-term emissions reductions can be compensated by increased ambition in the future. And it would be fantastic if there were more studies setting out at the country level what the limitations and consequences are that are created by that kind of delay. I'll just conclude by saying that we think these conversations and the kind of collaboration that UCS and others encourage is absolutely critical for litigation to succeed, and that we'd be delighted to deepen that collaboration with any of the scientists on this call. So thank you very much. I'll leave it there for now.
Great. Tessa, thanks so much. I just want to reinforce a point made in the chat to continue to put questions. A lot of questions are coming in, but we welcome more as our speakers are presenting. Thank you so much, Tessa. Our next speaker is Dr. Rachel Licker, a colleague at UCS, talking about attribution science. Rachel.
Sorry, I think that I've been muted. Okay, hopefully everyone can hear me now. So thank you so much for the opportunity to speak with you today. Following both Michael and Tessa's discussions where they laid out the role of climate science, I wanted to dig in a little bit more detail about the climate science that is relevant to litigation in this realm, because the litigation really is possible in large part because of such science. And in addition, further, as the field grows, we're really hoping to have more successful cases. Next slide, please. So I just wanted to start off at a very broad level to make sure that we're all on the same page by what we mean when we talk about attribution, because we really think about attribution all the time, whether it be things like tracing the role of subprime loans in the 2008 recession, the role of big pharma in the opioid crisis, even in ecology, figuring out how DDT was causing the decline in the bald eagle population. We just think about attribution in all sorts of different aspects of our society. So it's really not a new idea. Next slide, please. In the climate science sphere, things have started out at a very broad level. It started out with attributing global changes to human activity. For example, I'm showing you here a graph from the IPCC, or I'm sorry, this is actually from the National Climate Assessment, which on the left shows the change in global average temperature estimated by computer models run with both natural and human-caused greenhouse gas emissions. In orange, the average is the deep orange line. So that's showing you the model average of all these different models that were run to look at this change. And then the observations are the different colored lines. And on the right, you can see these same models run with just natural forcing, so the human caused greenhouse gas emissions removed, and you can see the model average in the dark blue line, and you can see obviously how different the observations are from a scenario in which we're only looking at climate with natural forcings. And this really helped us to attribute the increase in global average temperature to human caused greenhouse gas emissions. So next slide, please. So climate science then progressed to be able to tell us about the role of human-caused climate change in specific extreme events. So for example, with Hurricane Harvey, in almost real time, scientists were conducting work telling us about the likelihood of such storms occurring if we did not have human-caused greenhouse gas emissions. And this sort of work is improving all the time. One study that I'm showing you here, the results noted that global warming made Hurricane Harvey's precipitation about 15% more intense, and also made such an event about 3 times more likely to occur. Next slide, please. And this is happening with respect to other climate impacts, for example, extreme heat. And every year, the American Meteorological Society releases a really great report that has a lot of different studies looking at the attribution of different extreme events to human-caused greenhouse gas emissions. And so another such study looked at the 2012 heat wave and looked at the likelihood of the occurrence because of greenhouse gas emissions. Next slide, please. But now science is shifting to be able to not just look at climate change resulting from all human-caused greenhouse gas emissions. Now science is increasingly able to attribute changes to specific emission sources. So here I'm showing you a graph in blue of all global carbon emissions from all fossil fuel producers and cement manufacturers since 1850 in millions of tons. And you can see in red those emissions from just the top 90 carbon producers. This is work that was published by Ricchetti, and he found that nearly 2/3 of all industrial carbon emissions starting from the Industrial Revolution onward can be traced to those 90 top carbon producers. And these are both investor and state-owned fossil fuel companies that include the likes of ExxonMobil, BP, Chevron, Royal Dutch Shell, Peabody Energy, Gazprom, and Saudi Aramco, as well as different cement manufacturers. So again, the main point here just being that you can see that by and large, these corporations attribute a very large part of the emissions to date. And you can also see that most of the emissions have happened since the mid 20th century. Next slide, please. So my colleague at the Union of Concerned Scientists, Brenda Eckwurzel, worked with colleagues to run a simple climate model with those emissions data from Ricchetti and his study, and calculated the amount of global averaged surface temperature and sea level rise that is tied to the emissions from these 90 carbon producers. Brenda and colleagues found that the emissions from the extraction and products of these 90 major fossil fuel producers and cement manufacturers between 1880 to 2010 contributed to about 42 to 50% of global temperature rise. Next slide, please. Eckwurzel et al. Also looked at the increase, as I mentioned, in sea level rise attributable to these large carbon producers, and found that about 26 to 32% of global sea level rise between that 1880 to 2010 period can be tied to their products. Next slide, please. So my colleagues and I at the Union of Concerned Scientists extended this work last year, and we looked at global ocean acidification, because as the graph that I'm showing you here is, the graphs I should say, show global ocean acidification has a very well-known relationship with atmospheric CO2, and as well as surface ocean partial pressure of CO2 and global ocean pH. So there's basically a very direct relationship. As the atmospheric CO2 concentration increases, the pH of the ocean drops. Next slide, please. So we again ran a simple climate model looking at the emissions, this time of 88 large carbon producers. There were some mergers and acquisitions, which we accounted for, that had occurred since the time period that Brenda Eckwurzel's study had looked at. We extended it to a slightly different time period also, to 2015, whereas the other study ended at 2010. And we further looked at an additional period of 1965 to 2015, which is the time period in which carbon producers knew about climate change. And we saw that more than half of the decrease in the Earth's ocean pH can be attributed to the largest carbon producers, both over the longer time period as well as that more recent time period. Next slide, please. And you can find in the publication and the supplemental material all the results tied to specific companies listed here. So this is showing you the contribution over that recent time period of the emissions traced to specific carbon producers to the decline in global ocean pH. So you can see that, for example, Saudi Aramco has had contributed about 3% of the decline in ocean pH over the more recent time period, or their emissions in the more recent time period have contributed about 3% of the decline observed since pre-industrial times. And so the results of these studies can really provide references that can be used to determine that overall allocation of responsibility in legal cases that Michael was referring to earlier in terms of how do we come up with those numbers. Well, these kinds of studies can help to start to give those numbers. And of course, this is all, global scale, but we really do see opportunities at the regional scale to run regional scale models also with these kinds of specific emission sources so that we can get even more granular about the responsibility and the impacts that's traced to these different corporations. So next slide, please. So I'm just providing my contact information here and I'm happy to take questions and we'll pass it back over to the other speakers. So thank you so much.
Thank you, Rachel. Our next speaker is Dr. Benjamin Franta from Stanford University. Ben?
Hi, thanks for having me. I'll share my screen here. Okay, so I'm going to talk about the history of the defendants in many of these cases. And I want to say that I serve as a scientific and historical consultant for some of these cases. So what I want to do is go through the main historical behaviors of the defendants that are being addressed by this litigation. And really, there are three historical pillars of delay: internal knowledge, external disinformation, and greenwashing. And this is a useful way to think about corporate malfeasance across different industries. This framework also works for thinking about the history of tobacco, toxic chemicals. Different industries follow this same pattern where they know about the problem, but they fail to warn. They put out external disinformation to deny, and then at the same time, they misleadingly position their products as healthy or green in this case. And really the point of all of this is to create delay, and the damage is in the delay. So the longer we wait, the more damage there is. So I'm just going to give a couple of examples of each so you know what I'm talking about. This internal knowledge, this is an example of an internal report from Exxon in 1982. This was a confidential internal report not distributed to the public about climate change, and it contained sentences like this: there are some potentially catastrophic effects that must be considered. It predicted flooding on much of the US East Coast, including the state of Florida and Washington, DC. Stress associated with climate-related famine or migration globally. And even an estimate of adaptation cost, not even all of the cost, but just part of it. Cost of partial adaptation, a few percent of gross national product. That's about $400 billion today. And this is the sort of quantitative analysis that was done internally. This is from the same report from Exxon, predicting how much CO2 would be in the atmosphere over time, as well as how much global warming would occur. And if you look closely, you'll see that by the year 2020, Exxon was predicting about 420 parts per million of CO2 and about 1 degree Celsius of global warming. And so they were pretty much spot on. And so that's an example of this sophisticated internal knowledge that the industry had about climate change going back decades, and its failure to warn the public about the threat. And it puts all of the disinformation that follows into context because it shows what the companies knew. And this has been an incredible resource for doing research and gathering documents. This is the industry documents database hosted by UCSF. And you can go to it. I wouldn't go to it right now, but I'd go to it right after this whole webinar, and you can peruse it. And I think there's about 1,000+ internal documents from the fossil fuel industry on there so far, and more are being put up there all the time. Okay, external disinformation. We're moving ahead in time. The industry had a lot of internal knowledge developed between the 1960s and the 1980s. And by the late 1980s, when governments began to act more boldly to deal with the climate problem, that's when the external disinformation apparatus from the industry was rolled out in its full form. This is an example. This is in the Washington Post in 1997. Climate scientists don't say that burning oil, gas, and coal is steadily warming the Earth. This is one of my favorite examples because it's so simple. This is from William O'Keefe, Global Climate Coalition Chairman and an executive at the American Petroleum Institute. And so the Global Climate Coalition is one of the central nodes of climate disinformation from the late 1980s to the early 2000s. And researchers have found some of the internal membership lists from this organization. And so that is also informing these litigation efforts to see what companies were involved in spreading disinformation. And as you can see, there were many, many companies involved in this group. That's a membership list from 1989 when the group was formed. Fossil fuel companies, as well as electric utilities, automobile manufacturers, petrochemical companies, and others with an interest in the free flow of ever more fossil fuels. And there's been some very nice research done on this. This is from Robert Bruhl, a paper last year in Sociological Inquiry, where he's mapping out the different climate change counter movement or anti-climate policy, anti-climate action organizations over time. And you can see the Global Climate Coalition is just one of them, but there are many more. So this whole field of mapping out the organized disinformation apparatus is a research field in and of itself. And it's an exciting field, and that's an important way actually that researchers, social scientists, and others can deeply inform litigation. And then the third that I want to mention is greenwashing. Now, you might have seen recently advertisements from companies like ExxonMobil, like this one on its biofuels, or BP talking about how much solar energy it produces, or Chevron talking about how much it supports clean energy. These are all advertisements, and they run counter to how much the companies are actually investing in clean energy sources. This figure shows the capital spend between 2010 and 2018 of these different fossil fuel companies in percent. So you can see Total actually leads the pack, but it's still only about 2.5% of its CapEx is in low carbon energy sources, excluding the energy smart technologies. And it just goes down from there. So if you remember that advertisement from ExxonMobil or Chevron talking about how much clean energy they're producing or how much they're investing in it, at least in this time frame, it was only 0.2% of their capital expenditure. So that can be misleading if you're seeing an advertisement that talks only or mostly about clean energy, but in reality, it's only 1% or less of the company's investments. So that's one example of a kind of greenwashing. Another example is when the companies tell the public that they're actually supporting clean energy in the political arena, but they're actually not. And I actually haven't seen any legal complaints directly take that on because there's a lot of freedom around lobbying, but this is also a misrepresentation of what the companies are doing. And then finally, misrepresenting the characteristics of certain products, like natural gas, portraying natural gas as quote unquote low carbon, as clean, often by ignoring the methane emissions that are associated with the production and transport of natural gas, or calling hydrogen fuel a zero emissions or no emissions technology, when in fact 95% of hydrogen is produced from fossil gas. So this is another kind of greenwashing. So greenwashing, there's actually a lot of subtypes to it. And some of the complaints have pointed out the parallels between the current greenwashing going on and other historical examples like this. This is from the complaint filed by Massachusetts Attorney General against ExxonMobil, and it draws the parallel between what the ExxonMobil is doing and the tobacco companies did when they tried to misleadingly position their own products as light, as healthier, when in fact they were not. Like this ad from this person who wants to be fit and healthy. They decided they're either going to quit smoking or they're going to smoke True. So they decided to smoke True, a little bit like saying, I decided to either get off of fossil fuels or use fossil gas. So I decided to use fossil gas. And so that's a live area right there. And more research has to be done on that. So that's my main message to you. Historically, these are the main categories of activity that the fossil fuel companies are being scrutinized for, and together they form the historical conspiracy to create as much delay as possible. And these are a really important part of these lawsuits is investigating these things and holding the companies accountable for them. So I'll just leave it at that, and I welcome any questions you have.
Thank you very much, Benjamin. Our next speaker is Jessica Wentz at the Sabin Center for Climate Change Law. Jess?
All right, so I'll be talking about how scientists can get involved in climate litigation, as well as the broader legal discussion about climate change and how we conceptualize responsibility for mitigating emissions and adapting to impacts. Sorry, there's a bit of a lag. Oops. So in terms of direct involvement in litigation, there are several different ways that scientists can contribute to the factual development of, the development of factual records in these cases. One potential role is that of the expert witness. This is an individual who is typically solicited by one of the parties, but sometimes appointed by the court to provide testimony based on their special knowledge or proficiency in a particular field. And this can take the form of a written testimony or expert report, or if the case goes to trial, an expert witness will typically provide oral testimony at court. Expert witnesses play a very important role in terms of presenting and summarizing and interpreting scientific evidence in the courtroom. So for example, by explaining the significance of certain findings, clarifying the limitations of a study, or explaining how different studies or fields of research link together and factor into the legal arguments of the case. Being an expert witness is a fairly significant commitment. It's understandable that some scientists may have reservations about taking on that role. And so another role that scientists can also potentially play in these cases would be that of a consultant to one of the parties. And in this case, the consultant might provide technical guidance, for example, before a party even files a claim in order to help them flesh out their arguments and ensure they have an adequate evidentiary basis. Or a consultant might do something like review legal documents for the scientific arguments and the accuracy of those arguments. Scientists can also contribute as an amicus curiae. This is a Latin term that means friend of the court. And this is someone who has a special interest in the case. It can be an individual, a group of individuals, or an organization. And they will request that the court grant them leave to file an amicus brief in which they provide unique insight, expertise, or information aimed at helping the court resolve certain aspects of the case. So Juliana versus US, this is often referred to as the Our Children's Trust litigation. It's the youth lawsuit that was filed against the US government, alleging that the government had violated constitutional rights by failing to take action on climate change, and in particular by continuing to support the production and use of fossil fuels and not taking action to curtail the production and use of fossil fuels. And I wanted to highlight this as an example of a case where, even though it hasn't gone to a full trial, and it's not clear if it will go to a full trial, there's still a fairly well-developed factual record that contains a number of expert reports. And it's a good example of how different areas of climate science and attribution science and other realms, like more historical investigations, can be linked up through the testimonies of different experts to support the legal claims in the case. And I'll also just mention that the climate case chart that Professor Berger mentioned earlier is available. All of these documents are available on the Sabin Center's climate case charts. So in addition to direct involvement in the litigation, there are a number of other ways that scientists can and do engage in the legal discussion. Certainly just the continued scientific research is integral to informing both the arguments in cases and also, just as I mentioned, sort of broader discussions about responsibility for climate change. Published research can be submitted as evidence in these cases, even if you aren't an expert witness. And so depending on your realm of research and whether you anticipate that your research might show up in litigation, you might want to simply be mindful of this possibility and the fact that there is this broader legal audience for your work. There's also been a number of efforts to organize and link and synthesize research that are very valuable to the parties in cases. And this includes, as Tessa mentioned, the synthesis reports from entities like the IPCC and the National Climate Assessment reports. These serve two important roles. They help link up different areas of research and sort of flesh out the causal chain from emissions all the way to on-the-ground impacts. But also these organizations give a certain amount of authenticity and credibility to the research and findings contained therein. There have also been efforts to develop databases for sharing scientific information. The Sabin Center is currently working on a climate science database that's aimed at organizing resources primarily for the legal and policy community. And we are planning to launch this probably next month. And I just wanted to include this slide so you can see the URL there, climateattribution.org. And then the UCS also has a science hub for climate litigation that it will be launching. And that will be discussed later, but I just wanted to flag that here too. So scientists can also contribute through judicial training programs or conferences and seminars aimed at educating judges about climate science and also just the use of scientific information in cases in general. One example is the American Association for the Advancement of Sciences and Environmental Law Institute initiated this joint climate judiciary project. And this was the project that launched last year as a pilot project, and they had a series of meetings in New York and DC. So I just want to quickly wrap up by highlighting some topical areas where we will see scientific debate in these cases, if and when they do go to trial. So the basic science of climate change is fairly well settled. And so scientific disputes will likely focus on sort of the two ends of the causal chain linking emissions to impacts. And so in terms of responsibility and source attribution, as Tessa mentioned, in terms of framing government obligations, one important question will be how we can conceptualize effort sharing and what exactly the government responsibilities are in terms of emission reductions. And responsibility is also going to be a big issue in the cases involving fossil fuel defendants. And in those cases, the challenge for petitioners is that they'll need to establish both the validity of their emissions estimates, but they also need to respond to normative questions about whether companies should treat whether courts should treat the companies that produce fossil fuels as liable for the emissions generated from the combustion of those fuels. And I just wanted to note that as Dr. Franta detailed in his presentation, there is a very strong evidentiary basis for showing that these companies knew about the impacts of climate change and colluded to prevent the dissemination of that information. And this helps reinforce those more normative arguments about where responsibility should fall for the climate change problem. And it's a great example too of how more technical work on climate change attribution and emissions inventories can be combined with more historical research and company investigations in order to bolster legal arguments about responsibility. And then in terms of climate impacts and damages, this is a cross-cutting issue, highly relevant to all cases. The challenge for petitioners is to show that they have suffered an injury that is linked not only to climate change, but also to the specific contributions of the defendants in the cases. For the lawsuits involving government defendants, there may be different considerations depending on whether these lawsuits involve claims about damages to the public as a whole or a group of named individuals. Arguably, it should be fairly straightforward to establish potential and actual climate-related harms when looking at the public as a whole across an entire country. In terms of the municipal and state lawsuits versus fossil fuel companies, as Professor Berger highlighted, there's many cases that focus on coastal impacts. So for example, the Bay Area cases focus on sea level rise and coastal adaptation costs. But there are also a broad range of other impacts implicated in these cases, and it will be interesting to see how this affects and whether it affects the resolution of the cases. And then finally, in the context of cases involving claims related to the failure to adapt, whether impacts were foreseeable or will be, or future impacts are foreseeable, will be a major issue in these cases, perhaps more so than questions about causation and climate change. All right, so I will end it there. That's my contact information, and I look forward to the discussion.
Thank you so much, Jessica. Our final speaker before we go to Q&A is my UCS colleague, Dr. Delta Merner. Delta, you're up.
Wonderful, thank you. So I'm just going to speak for a couple of minutes. So Jessica demonstrated a number of ways that scientists can engage in climate litigation. Today, I want to present to you briefly the Science Hub for Climate Litigation, which is a new project at the Union of Concerned Scientists that works with experts that are interested in this nexus of science and climate litigation. More broadly, the Science Hub works to build greater capacity within the scientific community to conduct and communicate legally relevant research. This work, as hopefully we've demonstrated during this talk, helps to equip the justice system to make decisions that are informed by the most up-to-date evidence possible. So specifically, UCS's Science Hub for Climate Litigation has 4 main goals. One is to catalyze legally relevant research, such as the attribution work that was presented by Dr. Licker and the historical research presented by Dr. Franta today. Second, we seek to expand the community of scientists and legal experts working to inform climate litigation. The Science Hub supports this by sharing information and helping to bring together scientists who do work at the nexus of science and litigation. So for example, besides the webinar today, starting in October, we're going to be hosting a small web-based discussion series with experts that are interested in this growing field. We intend to have many more opportunities like this in the future. We also want to make robust litigation relevant research widely available and accessible to legal scholars, legal practitioners, local officials, and affected communities. And then finally, we're working to directly connect legal teams with relevant experts. So in order to do this work, we need all of you. If you are interested in the Science Hub and getting more involved, you can sign up to be part of the Science Hub directly through our webpage. Or if you have questions, you can email me, and I will also make sure that these links are available in the chat. So wonderful. Thanks, Peter.
Thank you, Delta. Okay, well, you've just heard from a very broad range of perspectives and areas of expertise around the relationship between climate litigation and science. And many of you have been prompted. We have now more than 40 questions in the Q&A, and we're going to turn to some. I don't think we'll get to all of those now, so forgive me if we don't get to your question, but we have about 20 minutes, 25 minutes to go through some Q&A. So let's just jump right in. I want to start with a question that I think is on a lot of people's minds, which is about for scientists who are looking to engage in informing climate litigation, what are the risks and what are the protections available to them to manage those risks? That's obviously a big topic, which we didn't get into here, but I wonder if anybody might want to just say a few words about that. I'm gonna point to Jessica if you want to take that on, but I'm open to others as well.
Certainly, I can chime in on this. Perhaps first I should just mention that the co-sponsor, the Climate Science Legal Defense Fund, is a great resource for any scientists who are curious or who want to, I guess, receive assistance if they are dealing with reputational attacks or problems like that. And that brings me to what I think a lot of climate scientists are aware of, which is that there is somewhat of an effort to, I guess, perhaps attack the credibility of climate scientists who might engage in the more policy and litigation debates. I know that sometimes people are concerned about stepping outside of the sphere of just purely neutral science and actually becoming, for example, an expert witness speaking on behalf of a case. But as I mentioned, there are resources available, for example, through the Climate Science Legal Defense Fund to help any scientists who are concerned about that.
Thank you, Jess. Yes, Climate Science Legal Defense Fund is a superb resource in this space, and encourage people to go to their website and look for more information there. There's a question about kind of the success of litigation as a motivator of climate action and accountability. Sometimes lawsuits can take a long time to go through the courts. Obviously, we don't have time on our side. Tessa, you had highlighted some successes around efforts to hold governments accountable for climate litigation. I guess this is sort of a two-part question. Is there a place where those successes and the lessons from them are accessible to others? Are they written up in a form that's shareable? And then also, how do we just think more generally about the potential for success of litigation as it moves forward? So why don't we start with you, Tessa?
Sure. I might hand the first question over to Mike, just because I know that, universities like Columbia obviously manage a database where they document all of the cases that have been brought, and also obviously Mike and his colleagues are responsible for a lot of the academic writing on this kind of litigation. So I think that's, the academic databases are where to start for documentation of these cases and their impacts, although often I think actually tracking the impacts of this litigation it's not easy because it happens at the local level, and it's usually the campaigners and the people who are really following the policy landscape at the local level who really know about what can be attributed to litigation and what can be attributed to other efforts to move climate policy in different countries. But yeah, certainly, I think the lesson from the Dutch litigation, and I think the lesson from litigation more broadly that seeks to compel reform in relation to issues that have, deep structural roots, whether that's, more human rights focused or environmental, is that the impact of these cases often depends on the advocacy strategies and communications and campaign strategies that accompany these cases outside of the courtroom. So it's one thing to win the legal argument, but especially when what you're seeking is an ambitious remedy, like an economy-wide emissions reduction standard, governments need to feel pressure from a lot more than just lawyers to be held accountable for that kind of change. So, I can speak again to the Dutch example, but, even while the Dutch government was appealing the initial decision of the Hague District Court, which was published in 2015, the Dutch Parliament, as a result of the level of publicity that the decision generated and the media attention that was trained on it, they voted to phase out coal-fired power as soon as possible. The Dutch Parliament enacted a new Climate Change Act that set a new emissions reduction target for 2030. So that's going way beyond the remedy that was awarded by the court. And so I think that's indicative of the kind of impact that you can start to have just because these cases put facts on the record. They sort of cut through the obfuscation and misinformation that politicians feel free to engage in outside of institutions where they're held to really exacting standards of proof and evidence. And these cases also are powerful in communicating the very present nature of the harms of climate change, which can otherwise seem, I think, quite remote. So it's really about how strategic litigants and their supporters are in running these cases, I think, that determines the quality and the scope of the impacts that the cases have.
Thank you, Tessa. Mike, do you want to pick up the baton that Tessa handed you at the beginning of her response?
Yeah, thanks. And thanks, Tessa, for your response. I agree absolutely with everything that Tessa said about the way in which litigation is really nested within a much larger context involving campaigning, social movements, politics, so forth and so on. I think that, the idea that any lawsuit will be a silver bullet or that litigation will be a silver bullet that solves the climate crisis is fundamentally misguided. Courts don't possess that kind of power in any context. And to, right the ship economy-wide greenhouse gas emissions is simply not within a court's power. And even if a court does come up with a broad declaration of the responsibility of a government or a corporation to take certain measures, there's still the implementation. And the implementation gets right back to what Tessa was referring to in terms of the need for constant advocacy, constant pushing, and so forth and so on. That said, litigation is a key part of the overall solution. And there are many impacts to litigation beyond victory in court that results in particular action by a government or corporate actor that are worth noting. I think that declaratory judgments from international courts that don't actually have jurisdiction over any particular entity can still shape the way that people think about and talk about climate change and the responsibility of different actors within that context. One story that I think is illustrative, and then I'll stop there to allow for more comments. Massachusetts versus EPA. This was a lawsuit that grew out of a petition that was first filed back in 2001, I believe, to force the United States Environmental Protection Agency to regulate greenhouse gas emissions from motor vehicles. That ultimately culminated in a US Supreme Court decision that didn't say that the EPA had to do that, but said that it needed to come up with a better justification for either doing it or not doing it. That decision in 2007, when the Obama administration came into power, wound up resulting in the greenhouse gas emission standards and fuel efficiency standards that were put in place, which have now been rolled back by the Trump administration. So we are now some 20 years after that petition was filed, and emission standards have come and gone. The litigation was a key instigator for the government's action. The solution is not done. We have not yet gotten vehicles to where they need to be, but we're much further than we would have been without the lawsuit. So I'll stop there.
If I might add just a little bit more from a historical perspective, I think it's hard to overstate the potential game-changing impact of forcing the fossil fuel producers to internalize, even just a little bit, partly internalize the full cost of their products. I think it's really hard to overstate the importance of that and the impact that that could have. And we have other historical examples of how to win in litigation. And a great one, of course, is the tobacco litigation. And that failed for 30 years before it started to succeed. And that's when the winning formula was found, which was to combine the science with the historical research that showed that the companies knew. That created this moral and legal culpability that came together with the epidemiology, basically the attribution science in that area. So we can learn from that. We can make this litigation, I think, this is my personal opinion, I think we can make it go faster than the tobacco case. And it's a powerful investigation tool, as was mentioned before. Tobacco is largely the poster child of corporate deception because of the litigation, because of the 15 million documents that were uncovered through discovery from the tobacco industry. And those are also hosted online at that database I mentioned, but that's how those documents were found. So we have the tip of the iceberg for the delay apparatus that has been operating for decades through through scholarly research, we found the tip of the iceberg, but through litigation, we can find much more as well. So, and put a stop to bad corporate behavior that's still ongoing. So to me, litigation is not the only part, but it's an extremely important part. That's my personal opinion. And it's hard to overstate its importance, I think.
Thank you, Ben. I want to just take a moment, as long as we're talking about the kind of industry side of the legal and science conversation about climate action and responsibility, just take that a little bit further. So in your talk, Ben, you noted that historical and social science research has shown, you get a slide to this effect, that misinformation campaigns, disinformation efforts involve companies beyond the fossil fuel industry. It wasn't just fossil fuel companies. So there's a litigation focus and a scholarly focus, as Rachel also spoke to, about fossil fuel companies and their contributions to the problem, and it's built into litigation. Now, what's the potential importance of justification for looking beyond the fossil fuel industry to the broader set of industry actors, both in terms of science and litigation? Is the singular, at least today, focus on the fossil industry responsibility the place things are likely to stay, should stay? I'm curious to hear what folks think about that. And Ben, why don't we just start with you, since you presented that work, and then open it to others.
Absolutely. Well, from a moral perspective, absolutely they should be held accountable, these other entities. From a legal perspective, I'm not a lawyer, I'm a law student, but I'm not a lawyer. And so, that's, I think other people can speak on that better. But from a human perspective, yeah, I think they should be held accountable, because it wasn't just the fossil fuel producers that engaged in promoting disinformation. At the same time, the fossil fuel producers had very sophisticated internal knowledge about the effects of their products. And that's a key distinction, is that the fossil fuel producers were producing the product. They knew the consequences that would flow from their products, and they promoted them anyway. The products were used as intended, and so on. So that is perhaps a slight difference from the companies that use fossil fuels as a feedstock for their own, but maybe not a huge difference, but it is one. So maybe I'll let some of the lawyers talk about the potential legal thoughts on that.
Do you want to pick that up?
Well, I guess I would just chime in on and note that, in talking about the cases against the fossil fuel companies, the issue of who else comes up a lot. Who else is liable? Who else might be liable? Who else is responsible for climate change when looking at the private side? The national governments is sort of a separate set of questions in some respect. And there are certain sectors that frequently come up in those conversations: the automobile manufacturers, the plastics industry, increasingly, big land management companies, forestry companies, agriculture companies, significant contributor to climate change globally, and others. But as Ben said, I think that there's a lot of knowledge about the fossil fuel industry's knowledge. There may be knowledge to be gained about others' knowledge, and that knowledge, and I noted that this was one of the questions in the thread as well. That knowledge is critical. It is critical not to all climate cases, but it is to at least some of them, that the actors knew about the harm that their products would cause. And so they should be held accountable for withholding or distorting that knowledge in order to profit. So I think that the answer to that question is yet to come in some respect, because it may be that these other sectors, these other actors are brought in at some point in the future.
Thank you, Mike. I want to turn to a focus on governments now for a little time. There are some questions in the Q&A that piggyback on some of the issues you raised, Tessa, about kind of burden sharing among governments. And so here's a question about, it seems that there's a strong case that needs to be made for the countries that have had long-term high cumulative emissions, such as the United States, to commit to greater reductions than countries who have had lower emissions. At some level, that seems inarguable. And yet I'm not sure that the IPCC, for example, as a scientific resource, speaks to that question in any direct way. So I guess my question for whoever wishes to take this up, maybe we can start with you, Tessa, is do you agree? And what do you and perhaps others on the panel think is the role for science, scientific evidence, to speak to the burden sharing question and conundrum?
Sure. So I think that approach that's been proposed, looking at the kind of historical cumulative emissions that countries are responsible for, is, I think, a very valid criteria to use to judge how much countries should be allowed to emit in future. And it is, in fact, one of the categories of effort sharing approaches that the IPCC describes in its fifth assessment report, where they actually outline, I think, about 40 different approaches to effort sharing. So historical responsibility is one, population, per capita, equal per capita emissions based on your current population is another, capacity to reduce emissions based on GDP per capita is another potential approach. There are also, I think, approaches that arguably have no real normative basis, but as I said, are clearly the political preference of high emitting countries, like grandfathering, where basically if you've emitted more in the past, you're allowed to emit more in the future. Cost efficiency is another approach that also disregards any historical or, I think, ethical basis for emissions reductions. And I think, what we're trying to encourage is more engagement with the question of, well, first of all, which of those effort sharing approaches are supported by some principled basis. And in our view, there are principles within international law in particular, such as the no harm principle, the precautionary principle, and others that exclude some of those approaches quite clearly, like cost efficiency or grandfathering. And more engagement with the question of how to apply those approaches to determine quantitative effort sharing ranges for individual countries. And I think the more engagement there is with that question, the more peer-reviewed science there is on that topic, the easier it'll be for courts to take those sorts of approaches seriously. Whereas at the moment, for example, there was a case brought against the German government in which there was one paper relied on by the litigants to demonstrate how much the German government should be reducing its emissions by 2020. And the court sort of took the view that that was a sort of cherry picking approach by the lawyers in that case, because there are all of these other approaches on the table. So I think the more we can narrow down those ranges that are really consistent with a principled approach to effort sharing and equity, I think the closer we'll be able to get to using that science. And that, as I said, it's also a normative exercise, so that opinion in courts.
Thank you, Tessa. Anybody else want to speak to that?
I'll just contribute that this discussion is very much linked to the discussion of common but differentiated responsibilities of countries under the United Nations Framework Convention on Climate Change. And I think it's absolutely true that additional research, but also to some extent consensus building on what exactly is meant by that would potentially help support better, more clear definitions of effort sharing and what that means for specific countries. But also, I just wanted to highlight the fact that in a lot of these cases, you have examples of countries that are very clearly exceeding their fair share of emissions, whatever that fair share may be. And so in that context, even without a very clearly defined effort sharing framework, it is still possible to bring litigation and, for example, an agenda at least holding a country accountable for reducing emissions 80% by 2050, these sort of basic frameworks that have been set out and agreed upon by countries that are parties to the United Nations Framework Convention on Climate Change.
Thank you, Jess. I want to turn to a question for Rachel. Rachel, the attribution science, the source attribution science that you walked through so effectively, in its current form, as you showed, talks about the contributions of entities, in the cases you've shared about fossil fuel companies, to changes in global climate. But a lot of the lawsuits, the damages lawsuits, the tort lawsuits are are focused at damages at a local level. What do you see as the kind of translatability or the potential for research to connect the dots to the damages that we're seeing in climate change in real places, in real time, and the contributions, whether it be of companies or other entities, other ways to kind of divide the pie to characterize their contributions in those specific cases? Can science bring us to that level of specificity?
I think it definitely can. We, as I was sort of alluding to when I spoke before, there is sort of a frontier that I think we're really ready to dive into in the research community, to take the specific emissions tied to different corporations and run, for example, regional climate models to look at some of the changes. We, in our ocean acidification paper, that we did together with Scott Doney at University of Virginia and Sarah Cooley at Ocean Conservancy and Ivan Lima at Woods Hole, we did a risk assessment framework that we employed the IPCC risk assessment framework to look at what's at risk of loss and damage in different places that have experienced disproportionate levels of ocean acidification. That using expert judgment, there's strong confidence that those changes due to known ocean circulation dynamics and such, are likely tied to the human-caused increase in ocean pH. So certainly, I think we're really right there at the cusp of being able to do that kind of research. And I have seen some really interesting questions floating around, for example, with respect to health, and can we tie health impacts to these kinds of emission sources? And yeah, I think that we really do have the data on hand to be able to develop those kinds of numbers and allocate responsibility more specifically. And I think, at the moment, the way that it seems to be happening is taking the larger scale numbers and, knowing that that the changes that are occurring in local regional places are directly proportionate often to the global scale changes. So we can definitely already use the numbers that we have, but I'm excited at the research prospects given what we have on hand right now.
Fabulous, thank you. So we just have time for one more question. I apologize again for not getting to all of them. There are a lot of good and energized questions in the chat. I want to just kind of take advantage of the forward look that Rachel just gave us around the potential of source attribution to get more specific in its relationship to impacts and damages in real places in real time, to ask others on the panel, drawing on a question that came in about kind of what you see in the offing in the next couple of years. What's going to break, either in terms of legal cases and their traction, or new developments, or perhaps other dimensions of the science that you see as emerging and potentially impactful as science and law connect to inform and support climate action. I'm opening this up to anybody who wishes to speak.
I'll take a first stab. So obviously, I think that the lawsuits against the fossil fuel companies, which I showed on the slide, are vital. And they are in progress, and we will see how those play out in the courts. And a lot of people have a close eye on that. But I think that the thing that people often aren't as conscious of are the types of cases I flagged at the end of my presentation, the failure to adapt lawsuits, where, and these can be against governments, as in the Pakistan case that Tessa mentioned, or they can be against private actors around their infrastructure. We're in the midst of an extraordinary extreme event moment right now, with wildfires raging in the West and hurricanes hitting the southeastern United States, as well as worldwide impacts. The failure to assess, take into account, and adapt infrastructure to these, and this is social and physical infrastructure, to these impacts, likely will lead to large awards of liability in the long run. It certainly could. And I think that that's a type of lawsuit that we'll be seeing an increasing number of. And that's another approach to internalizing costs that may have a significant impact sort of socially and economically.
Thank you, Mike. Others want to weigh in?
I'll just jump in with two quick projections. I think based on some of the chatter that's happening within the legal community internationally at the moment. The first is that there's a lot of interest in the prospect of interstate litigation. So a national government suing a national government in a jurisdiction where that's possible, whether that's the International Court of Justice or the International Tribunal on the Law of the Sea, for example. Because of course that, that poses, I think, a whole new range of questions around state liability that needs to be resolved at some point. And then I think the other broad area of interest that's emerging is how to basically engage in extraterritorial or cross-border litigation. So, it's one thing for a Swiss citizen to sue the Swiss government for impacts in Switzerland. It would be an entirely different thing for a Bangladeshi citizen to be able to go after a government in the global north in a high emitting country on the basis of the much more severe impacts that are being experienced there. And as Mike mentioned, there's a very interesting case that's being heard in the German courts that's been brought by a Peruvian farmer, but that's of course against a company that's headquartered in Germany. And I think the question of how to hold states accountable in their own courts by citizens of other countries is also one that's getting increasing amounts of attention.
Thank you, Tessa. Any others want to weigh in on this kind of crystal ball look ahead?
Well, I think from a social perspective, something you need to bring a lawsuit often, at least a tort, is to talk about the damages and talk about the injury received. And that we have a vague notion of that, that climate change is occurring and that it's damaging. But these lawsuits, I think, will drive a much more concrete and precise understanding of exactly what we have lost, exactly how much damage has occurred, where, and also the costs of delay. The cost of what if we had done something more 40 years ago, 30 years ago? What if the companies had not dissembled and denied and delayed? What could we have done? And so we will, I think as a society, this litigation will drive a much clearer understanding of what we have lost from global warming.
Thank you, Benjamin. Any other last comments before I close? We are almost at the end of our time. I want to thank all of our panelists for excellent presentations and discussion. It's obviously a rich area, a nexus that needs to be further explored, and really appreciate all of the participants as well, both for your joining us and for the questions, and for the help you are about to give over time in helping us build the platform upon this platform in strengthening the connections between science and climate litigation. It's obviously essential. There's a lot of room to build and grow and strengthen this network. And certainly at UCS through our Science Hub for Climate Litigation, as well as I know the work of our partners, we're all keen to make sure that happens and to support that. In the next 2 days, all of you who've joined will receive a follow-on email from my colleague Delta Merner. It will include an opportunity to provide feedback on this webinar, and also indicate your interest in engaging further in this work. So I want to make sure that you look at the webinar, look at the survey and feel empowered and motivated to tell us what ways that we, UCS and its partners, can support your further engagement at this nexus. Are there topics that you want more information on, that you want some training on? What skills do you want to develop? We are really building this community of scholars and practitioners together, and we look forward to your feedback and further engagement. I'll just note that one opportunity for engagement for those of you who are members of the American Geophysical Union, the Earth Sciences Society, that some of you at least I expect are, we'll be having a town hall, a virtual town hall on climate science in the courtroom that will dig deeper into some of these topics. Its date and time to be determined. We don't have that yet. It'll be in December, but you will all receive a note from us when we have that information. And if you're able to join us, we would both welcome and value your participation in that further dive into this set of issues. That'll be in December, probably in the first half. But that's it for now. Again, thanks everybody for joining us. Thanks to our partner organizations for sponsorship and to our wonderful panelists. And enjoy the rest of your day. Take care, everybody.